So there are certain basic ingredients that needs to be satisfied for this concept of lease pendens to be applicable. First of all, litigation should be pending in court of competent jurisdiction. The suit must be relating to right in a specific immovable property. The suit must not be collusive. Property should not be transferred or otherwise dealt with by any party to the suit so as to affect the right of the party thereto till the final disposal of the case. So there was another case wherein court said that there are like few like ingredients that we need to satisfy. Only in such a case we can say that this concept or doctrine of lease pendens would be applicable in a certain case, which is given under section 52. So what are these ingredients that we need to satisfy? First of all, this litigation or the case should be pending in a court of competent jurisdiction. So as we know, there are like territory-wise jurisdiction. For a certain matter that is happening in Delhi, maybe you should be filing the case in Delhi. You should not be filing the case in West Bengal. Similarly, there are pecuniary jurisdiction that a certain court can only give up to 7 years of imprisonment or this much, or it can decide a matter having a property involving this much of value, right? It cannot go beyond that. That is pecuniary jurisdiction, punishment-wise jurisdiction. Then we also have subject matter jurisdiction. Some matters can only go to some specific courts, right? Like a writ petition can only go to Supreme Court or High Court, right? It cannot go to some municipal courts or the civil court and stuff. Similarly, subject matter wise also we may have different jurisdictions, right? So this litigation that we are saying, it should be pending in some competent court of jurisdiction, whether it's relating to subject matter, whether it's relating to the amount involved, or it is relating to the subject matter of the matter. Court should be having proper jurisdiction to try the case. Okay, and it should be pending also, right? And when a case is pending, the moment this case is being filed, right, the moment this plaint is being given, from that moment until final order comes, and parties, like there will be this time limit given, right? If you remember, I guess somewhere we saw, right, that within 30 days parties can file an appeal and stuff. Do you remember reading that somewhere? There will be time limit given.
Yes, madam.
Right, so once this final order comes, it's not like immediately on that day itself you would go and file an appeal, right? You would also think about it. Okay, fine, is it, like, is there any use of filing an appeal or not? Then you would go for a lawyer, maybe ask for advice and all that stuff. So this thing is going to take some time. That is why time limit is being given, right? That after 30 days, after 90 days, you can file an appeal. Or like within 30 or within 90 days, you can file an appeal. So when we see this pending case means this time limit to file an appeal and stuff has also got over. Okay, only after that we can say, because parties can anyways go for an appeal, right? So in such cases, only when they have waited for this entire period, there is no scope of filing an appeal and stuff, then we would say that, okay, fine, now this matter is closed. Otherwise, we would say this case is still pending only. Okay, and court of competent jurisdiction, it may be with regard to any type of jurisdiction wherein the matter is pending. Next one is suit relating to right in a specific immovable property. So whatever case we are talking about, it should be relating to rights of parties in a certain specific immovable property. So it would be applicable in case of immovable properties only, and not where subject matter is movable. First of all, it should be immovable. Secondly, the litigation must involve a specific right in immovable property, such as a dispute with regard to title of the parties. That one of the parties is saying that I don't believe that this person is owner of this property, or might be he is claiming his own rights over the property and stuff. Possession or a right of alienation. Maybe I'm saying that, okay, fine, this person is an owner, but I have a right to stay there. I have a right to possession of the property. Or it may be with regard to right of alienation. I want to transfer the property. So do I have a right to transfer the property or not, etc. It would apply in case of sale, specific performance of contract. Might be sale transaction is done on paper between two parties, but possession of property is not being given. In such cases also it would be applicable, right? It may be applicable with regard to mortgage, easement, preemption. So there are a lot of cases wherein main thing is that this property is involved, right? And a question relating to this property, we are, like interest or rights over a certain property is being concerned. In such cases it would apply. And one more thing is that it has to be one specific immovable property, right? When we are filing the case, it has to be like clear regarding which property. Like one person may be having 10, 15 properties, but in the case, right, it should be specified that which specific immovable property of this person are we like mentioning in the case. Only in such a case, this concept would apply, not otherwise. If it's like a very vague that some immovable property of this person, then it may not apply. Okay, so it's not applicable with regard to debts, rent, house tax, etc. So if there is a case being filed that this person stayed in my property for like 8 months, he did not pay the rent, for recovery of money, I'm filing a case. In that case, I still have a right to like sell the property or whatever I want to do, because that is like a different thing, right? It's not related to ownership of the property or stuff like that. I'm anyways owner. Just the thing is that this person stayed in my house as a tenant. He did not pay the rent. So that matter would not affect this, my right to alienate the property or do whatever I want. Similarly, with regard to payment of tax and stuff also, right? So that is the second one. First of all, having like a court of competent jurisdiction wherein the matter is pending. Secondly, it has to be some specific immovable property and the cases with regard to rights over that specific immovable property. It should not be some other related matter like non-payment of rent, recovery of money and all that stuff. Thirdly, the suit should not be collusive. So what is collusive? It basically means that suit is like a fake one. Okay, it's not like a genuine case being filed. It's basically like a conspiracy, right? Two persons decided that, okay, fine, let's do one thing. You file a fake case against me and we would, like make the concept of lease pendens applicable on us and we would cause loss to this person. We would cause wrongful gain to ourselves, right? So it should not be like conspiracy, it should not be planned, or it should not be a fake case that parties are basically filing. In such a case, this concept would not apply. So it is, take for example, where the parties to a suit enter into an agreement, okay, with the intention to defeat the rights of the transferee. The suit presented or pending must be genuine one and not a collusive one. So if, take for example, I have entered into a contract with someone that I am selling my property to you for a certain amount. At the same time, I entered into an agreement with one of my friends that why not you file a case against me? Okay, take for example, my friend knows that I am owner of this property, but still my friend goes to the court, files a fake case with regard to my title, okay, that I'm not owner of this property, but my friend is a owner or something like that. All right, so this is a fake case which is being filed just in order to ensure that this doctrine of lease pendens is applicable on the property, so that whatever money I'm taking from this person, I will take. After that, I will say that no, this property is pending in so and so case, right? Those should not happen. It should not be a fake case, but only in genuine cases which are being filed by parties, this concept is going to be applicable. Okay, so the case must not be collusive one. That is the third one. Fourthly, property should not be transferred or otherwise dealt with. So this term transfer would mean absolute transfer as well as partial transfer. So this doctrine applies with regard to sale, lease, mortgage, etc. also. Because in case of sale, it's absolute transfer. In other cases, it is partial transfer. If you may be giving possession of the property, you may be allowing the person to have property documents and stuff like that. So it will be applicable with regard to transfer of complete as well as partial ownership or other rights over the property. Otherwise dealt with includes that the case which is not that the cases which are not covered by Transfer of Property Act. It includes the case of partition. Any transfer made with the permission of court and in accordance with the term imposed by it will not be subject to lease pendens. So basically, right, whatever matters are related to transfer of like complete or partial rights over the property, in all such cases this concept is going to be applicable. But as I told you, right, these concepts are based on this concept of justice, equity, and good conscience. That means court is going to see what is right in a given situation. It's not like one hard and fast rule is there that they would apply, but rather they are going to use their own mind, try to analyze that specific situation, and accordingly may give a relief also, like an interim relief also they may give. Take for example, otherwise it says that, okay, whether it's absolute transfer or partial transfer, you should not be alienating the property. But sometimes, right, if court feels that, okay, fine, it's okay, case is going to take some time to decide, so you can, like maybe mortgage the property or you can do this. So court may allow, right, with court's permission, with the conditions which court has fixed, if parties are following those things, they may alienate the property. They may do certain things which court is allowing them to do. Basically, they can ask for permission of court that, can I do this thing or not? And court may accordingly pass an interim relief based on the situation. Okay, so that is like on discretion of court, in which cases they would provide what sort of relief. By any party to the suit. The parties to a suit include the ones who file the plaint or petition, that is plaintiff, and the ones against whom the relief is prayed for, that is the defendant or their representative on their demise. So in case parties die, their legal representatives are fighting the case, or in case or in case there is, take for example, there one person dies, there are like 2-3 people involved. Okay, like this recently happened, okay, in like in a place near my house. So there is this concept of different schools, right? In family law, Muslim law you have studied, right? Different schools are there.
Yes, madam.
Similarly, in Hindu law also, like we have these different schools. Okay, so what school is followed here in Assam and West Bengal is Dayabhaga school. Okay, so as per that, initially was like property would be going only to the son. Okay, but after this decision came, right, 2017 or what, that no, equal share, daughter is also having, son is also having, right? So what happened, right? Even after that, in most of the places, right, property is like still straight away would go to the son, but daughters are not basically involved. If they want to claim for it, they would basically go against their family, file a case in court, and then get their rights enforced. So mostly they don't prefer filing a case against their family members, and they are just okay with it. All right, so recently I saw one case where it was like 3 sons were there and I guess 1 daughter. So property got like divided amongst those 3 sons. All right, and this daughter, she filed a case at a later stage, like they demolished the previous construction, they contracted with a builder, gave the property to builder also agreed that, okay, we are going to construct like a 4-story building. Once this construction was like half done, she went to the court and filed a case that I also have a right. Now there is like a complete stay on the property. You cannot do anything on the property unless and until this matter is being decided. So those sort of things would apply, right? By any party to the suit. Might be the property already got transferred to the sons, or might be the father only like orally he said that, okay, fine, I'm going to give this property to you three. So you three decide what you want to do, right? That case also it would be applicable. That might be the person died, property has not yet got transferred, but they are in the process of getting it done, whatsoever is the case. Okay, so it would be accordingly applicable that by any party to the suit, if there is some matter relating to it, with regard to it, this concept is going to apply. They cannot say that, okay, we are legal representative only, we are filing a case, but this property still belongs to our parents. That would not apply in this case. All right, it would anyways be considered as a pending suit only. The transfer made by a person before he is made a party to the suit is not affected by the doctrine of lease pendens. Sometimes what you may notice, right, like a case is being filed maybe between two parties. Okay, there is one person versus one person. But once they start with the process, right, they would gradually realize that, okay, fine, this person is also related to the matter. So let's include this person also as a party. After a few months, let's include this, let's include this. Like that, there may be like 10 different persons who are being included. Okay, but initially what happened? It was this one person versus this another person only. So if before being made a party, all right, I was made a party at a later stage. Before I was made a party to the case, before that, if I have done something, there this concept would not be applicable. Okay, the transfer made by a person before he is made a party to the suit is not affected by doctrine of lease pendens, because I did not even know that I would be made a party to the case. So I accordingly did my part. In that case, this concept is not going to apply, because until that time, there was no pending case basically. Right? So it would be by any party to the suit, whether it's legal representatives, owners, or other stuff. So there is this just example. You understood this part, right? At a later stage, they are being made party. All these points, is it clear?
Yes, madam.
Basically, there's this example that A is owner of the property X, which is managed by B with the permission of A. B sells the property to C. C files a suit against B, that is the manager, claiming the possession of the property X, and C is not made a party to the suit. Meanwhile, C sells the property to Y. As C is not the party to the suit, the transfer made by him is not going to be affected by it. There is one more ingredient, that is so as to affect rights of the party thereto. Basically means that this alienation or transfer that you are doing, it is going to affect right of any party in the case. Because if I'm going to court, filing a case, asking for some rights, and in the meanwhile, you already sold the property to someone, in that case, it is going to affect my rights. Even if court gives a decision in my favor, I cannot basically enforce it, right? I will again have to go file a case against this other person and stuff. That is why this concept of lease pendens is applied, that it is like a concept in order to prevent that this alienation would affect my rights, because I'm already claiming for my rights. So it is some sort of a concept which is trying to restrict any sort of alienation which is going to adversely affect my rights with regard to the property. Okay.